Well, hey there. One of the most common concerns I hear from people is my older parents' behavior is concerning me, and I'm worried about their mental health or their abilities. There can be cases where we're not talking about dementia, but in my example today, we are. Oftentimes, unless a person has done a great job when they're planning ahead, it can be difficult and really messy for someone to intervene. The other day, I was talking about capacity and competency, and this brought up a ton of comments around becoming or being someone's DPOA. I received a great question from Robert, and he asked, is he the automatic DPOA of his mother because his father recently passed away? Robert is 58 years old, and his father was the primary caregiver of his mother. Robert's mother is in her early 80s and had a diagnosis of dementia at least 10 years ago. Robert lives in the same town as his mother. He's married, he works full time, and he enjoys spending time with his grandchildren. He said that he noticed that his mother is not fit to live at home, and this has become very apparent after the death of his father. Robert said that his mother makes poor decisions. She's unable to care for herself at home. She's unable to cook for herself, and he wants to place her in a care facility. But he says that he's not able to care for her in his own home. Robert has checked out a few homes in the area, but found that because his mother does not want to move, he cannot make the decision and is worried about her safety. So first, let's clarify some things. The term DPOA stands for Durable Power of Attorney, and it is a legal term, and it's a legal document that lets you appoint someone to manage your financial, legal, and medical affairs if you become unable to do so yourself. A DPOA remains valid even if you become incapacitated. This ensures that your affairs are handled according to your wishes without the need or intervention from a court. Oftentimes, I find that people will call themselves a DPOA, but really what they need to say is that they are the agent. That is the person that is appointed by the principal, the person writing the document or the person who had help writing the document. And that's the person that they appointed to handle their affairs. Now, the other day I spoke about the need for a person to become incapacitated for an agent to become activated on behalf of the person with dementia or the person with cognitive impairment or concerns. Well, that's because that's true here in Michigan. However, I did find out that not all states require someone to be declared incompetent before a durable power of attorney agent becomes active. The requirements for activating a DPOA vary state by state, and specific terms are outlined in the DPOA document that your loved one creates. But here are three common scenarios. There's immediate effectiveness, because in some cases, a DPOA might become effective immediately upon signing, which means that the agent named, you or someone else, on behalf of the person, the principal, so the agent would have the authority to act on behalf of the principal right away. So in that, for instance, you would have the ability to make decisions on behalf of your person right away. They don't have to be incompetent. They don't have to have been declared incapacitated. The second instance is a springing DPOA, which is designed to spring into action or effect only under certain circumstances are met. Those conditions would be being declared incompetent or incapacitated. And in these cases, the document, the DPOA, will typically specify the conditions that must be met in order for the DPOA to become active and the agent to be able to make decisions for the principal. And I know these terms are a little bit confusing, agent and principal, but if you think of yourself as the caregiver, as the agent, and the principal is the person you're taking care of, that might be a little bit helpful. But anyway, the springing DPOA becomes active under certain conditions like incompetence or incapacity. And then there are some states that have certain requirements, and those requirements may, you may have to default to the rules of your state for activation of a DPOA. For example, I guess like some states may require a physician's certification of incapacity, while others might have different criteria. So if you live in a different state other than Michigan, you're going to have to consult with your state's rules and regs. In my opinion, though, it's super important that you start these conversations early with your loved one. For me, I am an only child, and I have been very clear with my parents that while I do have a medical background and knowledge and the ability to make very thoughtful decisions for my patients and their families, I am very certain that in the case of either of my parents, I will be super emotionally driven. I am emotionally driven by nature, as you probably can tell. And in the event that something happens to my parents, I am going to have that emotional turmoil. And so I told both of my parents, please be very clear in your documents what you want done in the event of an emergency. Please don't leave those the making of those decisions left to me. Both of my parents are of sound mind, and I know that at least my mother has given me the ability to speak to most of her doctors. She's given me her consent. She's given them consent to speak to me. So if I have questions regarding my mom's care or some of the goals, or question something that she's said to me, if I wanted to, I could technically reach out to her primary care provider and ask them questions about the care. And then that way I could explain it to my mom, or she and I could discuss it and determine what would be a more reasonable goal or more doable for her. But what this does not allow me is it doesn't allow me to override her decisions, because she's capable of making her own. So just because your person has DPOA paperwork doesn't mean that you're the durable power of attorney right away. You may be making concomitant decisions with your person for a while or until their death. You may never need to become their DPOA. And if that's the case, then you need to make sure that your person gives written consent for you to make decisions or to talk to medical providers and share information. But let's say that my mom wasn't competent or didn't have the capacity to make her own decisions. In that case, I would need to consult with my parents' legal paperwork, their legal documents, their DPOA, their living will, to determine if the requirement for me to become her agent was springing, meaning does she need to be declared incompetent, or does she need to be declared incapacitated for me to take over her as her agent, or is it immediate? Meaning she doesn't need that. I would also, because she lives in Florida and I'm not 100% certain of how it works in Florida, I would likely have to seek legal counsel because I don't know their rules in Florida. But I would have to have her paperwork in my hand. I would probably have to seek legal consult to determine how I could take over caring for my mom. And that's And that's saying that my dad wouldn't be there to make those decisions. So with regards to Robert, this will also be true for him because his father was caring for his mother for so long, and he didn't need legal paperwork to take care of her or manage her affairs. But Robert will have to find her DPOA paperwork, her legal paperwork, read over it, and determine who assumes medical care, who assumes financial care for his mother now that his father has passed. And then he'll need to determine, is this document in effect immediately, meaning she doesn't have to be declared incompetent or incapacitated, or does he need a medical determination of incapacity to assume the role of agent? So my best advice based on my experience as a medical provider to thousands of patients at this point in my career, if you can start having these conversations early with your aging parents, if you're able, go over any legal documents that they might have. Ask questions now so that you can determine, are you the right person to assume the particular role? So if I had a sibling, maybe my sibling would be better at math than I am. So my parents might appoint me the medical decision maker and my sibling the financial decision maker. And that would be a split role, and it would be specified in their DPOA paperwork. Which of us became the medical agent? Which of us became the financial agent? A power of attorney generally specifies what kind of activities and decisions the agent can make on behalf of the principal, the person. Whether the agent's power is effective immediately or only once the principal is declared incapacitated. Whether the agent's powers remain in effect after they become disabled or incapacitated. A durable power of attorney, because there's a difference between a general and a durable, but we're only going to talk about durable to keep it simple. A durable power of attorney stays in effect even if the person who created it becomes incapacitated. And this tool, it provides a means to plan ahead. It allows them to say what their wishes are. And if your person has those papers into effect, like I said, my suggestion is that you get with your person, you go over this paperwork if you can, and if they're not capable, then get out the paperwork anyway, go over it so that you know what role you're to play, or if you have to share that role with your sibling. Remember, we can always hope for the best, but plan for what's possible. So again, it's essential. Make sure you're reviewing those terms of the DPOA documents and consult with an attorney to understand the specific requirements in your state and how this document should be drafted if your person doesn't have it to meet the needs of your person, the wishes of your person, and what you're capable of doing for your person on their behalf. If you have any questions or any comments, please drop them below. I will be checking back and checking to see what you've said. If you've had a situation where you, like Robert, were going to do something and you couldn't because you didn't have the appropriate paperwork in place, share that with us. Talk to us about your experience. And as always, have a great day. Next week, I promise to talk about something a little bit lighter than capacity and competency and what it requires to become a DPOA. All right, have a great day.